Welcome to Collier County Court. I'm Judge Martin. I've got two matters set for 2 o'clock. And I noticed, I think Ms. Hall was in the virtual courtroom first, so I'll call that case first. McEachern versus De Oliveira. Ms. Hall, I believe you're here on behalf of plaintiff, is that correct? Ms. Hall, I have no video or audio for you. You're muted with the camera off. Are you with us?
I am, Your Honor. Yes, I have, my Inns of Court background is still on and I haven't figured out how to change it. So I have the Greek ruins as a background. So I figured, unless Your Honor would request video, I figured I would not have that.
That's okay. I can tell you how to fix that, but that's fine. All right, and do we have anybody here for Renata De Oliveira or Magic Paws, the defendants in this case?
Yes, Your Honor. I'm Renata De Oliveira and also answering for Magic Paws LLC.
Okay. All right, Ms. Hall, this is your motion for summary judgment on the count for damages. Is that correct?
Yes, Your Honor, that is correct.
All right, I'll invite you to go ahead and proceed.
Okay, thank you, Your Honor. We have already obtained a motion for summary judgment and possession of the property pursuant to count 1 of the complaint. We're here only on count 2, a motion for summary judgment as to damages. I do want to note as a minor housekeeping issue that Magic Paws is a corporation under the state of Florida, and as such cannot represent itself. So Magic Paws would need to have an attorney present to represent Magic Paws. However, I do understand that Ms. Oliveira could represent herself in this proceeding. Be that as it may, and I assume I know that will become more relevant as my argument progresses. However, the basis for our motion for summary judgment is set forth in the motion. At this point, pursuant to Rule 1.150, the moving party, that being the plaintiffs, have filed the motion and affidavits in support of not just the allegations within the motion, but also as to the amount of damages. And specifically by damages, I'm referencing the lease amounts, the rental amount. The affidavit also pertains to attorney's fees, but at this time, the plaintiffs would only be seeking an entitlement to attorney's fees with the court to reserve jurisdiction to determine the amount. Okay. However, the affidavits, and there have been 2 affidavits filed by plaintiff's representative, Mr. Carson McEachern, on behalf of the trust. He's one of the co-trustees, establishing the total amount of damages for the missed rental period. And as of yesterday, there was no counter evidence filed under the rule to contest the evidence that has been filed in support. So based on Rule 1.150, the plaintiffs are seeking a final judgment in the amount of the rental fees and the late fees, with the court awarding an entitlement to attorney's fees under the terms of the lease and Florida law, and reserving as to the amount.
And tell me, just so I make sure I've got the correct figures, the rental amount that you would seek in a judgment today is how much?
I'm sorry, Your Honor, let me pull that up for you.
I think I know the answer to my own question, but between the 2 affidavits of Mr. McEachern, there were some significant differences. I think what it was is that the 4203.19 includes tax and late fees, but one of the affidavits broke those out, and one of the affidavits suggested there was $3,100 in late fees, which I thought was unlikely.
Yes, I'm looking at the most recent one that was updated on February 2nd.
Right.
And the total late fees in paragraph 19 are $232.50. The late rent is $4,203.19, and then costs to enforce the terms of the lease include, and of course that I would ask that the court reserve as to the cost, but for the court's knowledge, that does include the costs that were incurred as part of the ejectment action and the writ of possession. So it would be, and I'm just gonna have to do math so that I can break it out.
I show 461.60. Is there more than that?
32. No, Your Honor. That seems to comport with my math, which I will concede is not excellent.
So you seek principal amount for rent $4203.19, late fees of $232.50, and costs of $461.60, and then entitlement to fees we would reserve jurisdiction to determine the amount. Is that all correct?
Yes, Your Honor. And now that I'm looking at my math, I think I've messed it up. I think it's $232.50 and $461.60. The amount I have showing is $4,897.29, all told.
Okay, I'm more concerned about the three components than the grand total. But the $461.60 is the correct cost number. Is that correct?
Yes, Your Honor.
Okay, all right. And Ms. De Oliveira, this is a pretty technical process. The plaintiff has made a few assertions which are correct, but probably are new to you. First is that only an attorney can represent your corporation. I understand you might be the corporation all by yourself, but only an attorney could actually represent them. You can represent yourself. And if I understand correctly, you have guaranteed these rents in a personal capacity. So ultimately, you're here to protect your own concerns. Did you understand all of that so far?
I do understand now. I found out later. I'm not familiar with Florida law. I just moved here from Connecticut, but anyhow, I didn't know that I could not represent Magic Paws. The corporation, Your Honor, has been dissolved at this point. At this point, it's been a while, and the reason being because I don't want to continue paying taxes or have any fees associated with that corporation. Okay. But I do know that I have to represent myself, and so here I am. Okay.
Well, the second technical point that Ms. Hall raised correctly is that the process that they are using today is called summary judgment, and it allows them to get a judgment if there's really no controversy, no debate, nothing to fight about in court. And so they have filed these affidavits representing that about $4,200 in rent is outstanding, with a little over $200 in late fees, and then their cost to get through the suit this far is $461. They're also seeking their attorney's fees, but they're indicating that they are still figuring out what the amount would be, and they will ask me to give them attorney's fees at a subsequent hearing. The rule says that if you disagree with any of their affidavits, with any of their assertions, then you have to file your own affidavit. And you have not filed an affidavit.
I'm sorry to interrupt, Your Honor. I did not receive any communication about having to file the affidavits. The only thing that I received in the mail was regarding this meeting, and today actually I had to call in to get the Zoom meeting ID number, but I have not received anything in the mail. Otherwise, I would have contested because I have filed in time, before. So I just a little confused about this communication.
Well, we don't, the documents don't necessarily tell you everything to do. You can consult an attorney if you want legal advice, but all that they have to do is send you a copy of their motion. They sent the motion out in early December, would have been about 48 pages.
Yes, I probably don't know at this point what it is. I remember having a lot of papers sent by the attorney. I don't know how to read legal papers, and the other thing is I am not in a financial situation that I can actually hire an attorney. That's one other reason why I'm here representing myself.
Okay, I understand that. This is a situation, unfortunately, there's a lot of people in your position. Do you have any legal objection to what they are requesting here, or is it simply a matter that you do not currently have the money to pay that? Is there any controversy here?
Just about the amount of rent owed. I would like to have that, because when I was I received the notice of eviction, it showed a different amount. It showed somewhere around $2,000. So I don't know what this $4,203 is coming from.
Okay. Well, some more time went by before they actually got you out of there. I think we had a couple more months worth of rent. Do I have that right, Ms. Hall?
Yes, Your Honor, that is correct. It was at least 2 more months between the last notice and
Well, I'm losing.
Sorry.
In possession of the property. So that is why the number is noticed.
Okay, can you state that last part again? Your audio went out pretty completely.
Sure, I'm sorry. Can you hear me now?
Yeah.
Okay. Ms. De Oliveira is correct. The last notice that she was sent that was posted was a few months prior to the plaintiffs being able to regain possession of the property. So from the time the last notice was sent until we were able to obtain possession with the sheriff, that amount of rent has been added. So that's why the amount is different.
Okay. Ms. De Oliveira, do you have any other question, anything else that you dispute about what they're claiming?
No, Your Honor. I believe the other fees, the court fees, right? The 461.
Yeah.
And what is the 232.50 again?
That's late fees.
Late fees. Okay. Now I'm not contesting that. I would like to. I want to pay what I owe, but I would like to know if it's possible to reduce that amount. I'm not sure. I'm just asking, and if time can be some kind of installment can be made, because I don't have that money right now.
Okay. Well, what I'm going to do is this, and I appreciate everybody's patience here today. I'm going to grant the plaintiff's motion for the damages that we've discussed. I will include a note that I'm reserving jurisdiction to determine the amount of the attorney's fees, but I am finding that plaintiff is entitled to recover those in addition to the other amounts. And Ms. Hall, I'll ask you to forward an order to that effect. And Ms. De Oliveira, you are free at any time to contact Ms. Hall and speak to her to see if there's any room to negotiate or craft any sort of a settlement or a payment plan. I don't play any role in that, and I can't push either one of you to be more reasonable or anything like that. But you're always free to speak to each other and see whether any agreement can be reached to maybe try to set up a payment plan or negotiate a lower amount, you can explore that directly with Ms. Hall, okay?
Okay, Your Honor.
Ms. Hall, is there anything else I need to address for plaintiff today?
No, Your Honor, I would only ask if Your Honor would prefer if we email a proposed order to you in Word format, or how would you prefer that?
Let me just look. I think if you want to just send it in Word format, Ms. De Oliveira, do you have an email that you use regularly that you would like us to use so you can get immediate copies of things?
Yes, Your Honor. It's Renata, my first name, RENATADEO 2014 @gmail.com.
Okay, Renata DEO 2014 @gmail.
Yes.
Okay, we'll do that. And Ms. Hall, if you want to just copy Ms. De Oliveira at that address, just submit by Word, and then we will execute it, and you'll both get copies immediately through the court e-filing system. That'll be a lot easier for you, Ms. De Oliveira, to get things promptly, even though you may have changed your address and so forth, okay?
Okay, Your Honor, thank you.
Okay, Ms. Hall, anything else that plaintiff wishes to address?
No, Your Honor, thank you.
Ms. De Oliveira, anything else I can clarify about what's gone on today?
Just now that what's gonna happen as far as the Magic Pulse LLC? Am I going to need an attorney? What's how that works?
I can't really answer that for you because answering it would mean I'm giving you legal advice.
Okay.
Certainly you can consult an attorney. If you need a low cost attorney, you might contact, just Google Collier County Bar, and you can see they've got a lawyer referral service that will help you get a consultation for a low cost. And you may just try to at least get some advice on that as to whether you should get an attorney or whether you don't need to.
Okay, thank you.
All right. Good luck to both sides. That'll conclude our hearing on the McEachern case.
Thank you, Your Honor. Have a good afternoon.
Thanks, everyone. The other matter for 2 o'clock is Nobles versus United. Do I have anybody present for that?
Good afternoon, Your Honor.
Good afternoon. Looks like this is Mr. Miles.
Yes, I'm on behalf of plaintiff.
Okay. All right. And I haven't seen anybody else attempt to join us. You've been waiting patiently. Do you have an agreement maybe?
Yes, I believe OC, opposing counsel, sorry for the abbreviation, they sent over an agreed order that we agreed to for them to schedule the depositions within 20 days, for them to occur within 60 days. That was sent maybe at 1:30 to your judicial assistant.
Okay. Okay. It may be in here. We're both getting peppered these days. Criminals on hold, but civil's on fire. So I will check with her and make sure. And if she doesn't have it, I'll have her reach out to you. But I'm appreciating that. I wasn't thinking this was something that I normally would need a hearing on. So I'm glad you all were able to find an agreement, and I'll get the AO back out to you right away.
Perfect. Thank you so much.
Okay. Take care, Mr. Miles. Thank you.
Have a great rest of your day, Your Honor. Bye.
Okay, we'll be in recess until 2:30.
I can't answer. Can you help me for a second? Jody, can you help me for a second? I finally got it on my computer. but I'm on the phone waiting as well. This is what they sent me. But it's telling me I can't log in.
How can you not log in? But I'm here.
Oh, all right. Well, I'm on the phone, Tommy, but I just can't log into what they're telling me to log into. Okay. Sorry, I can't pick up this page. Go back. I need to say confirm that I'm here, but I can't log on. Or do I need to review? Like, maybe? I have to download Zoom Cloud, Tommy. Mm-hmm. Thank you. Okay, continue. All right. I'm downloading the Zoom Cloud meeting. Do you want me to send you the link?
To me?
Yeah.
I'm not going to be able to get on Zoom. I can't download that on
Okay.
this phone.
Okay. Okay. Meeting ID.
Where they at?
Hold on. 649667865 join. Join without video. I don't care. Just get me in. Okay.
Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. I've just been waiting. I know Ms. Mangan's, I assume that's Ms. Mangan trying to get set up with the technology here. So I've just been, I didn't want to be breathing down your neck while you were doing that, Ms. Mangan.
Hi.
How are you?
I am fine. You?
Good. And I think I've got counsel for Suncoast on the line.
Yeah.
Do you want to
Yeah.
come back on?
Yes, yeah, I'm here, Your Honor.
Who are you? Are you Mr. Pritchard? There you
Yep.
are.
Sorry about that.
Okay. All right. And it's Pritchard.
That's correct.
Okay. All right. Okay, Ms. Mangan, you have filed, I believe, a claim of exemption to a garnishment. And
Yes.
this is the hearing regarding that. And so, Mr. Pritchard, what I typically do, I'll swear her in and I'll just ask her some standard questions and then invite you to follow up with whatever else you want to cover.
Yeah, thank you.
Okay.
That's
So,
perfect.
Ms. Mangan, do you want to raise your right hand for me? Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. All right. Would you tell me your full name?
Renee Lynn Mangan.
All right. And how do you spell your last name? What's the correct spelling?
Mangin.
Okay, great. And are you employed?
Yes, I am.
Where do you work?
Physician Regional.
All right. And what do you do for them?
I'm a nurse.
What sort of nurse?
I work for a dermatologist.
Okay. So
I'm an LPN.
What is it?
LPN.
Okay. All right. Dermatology LPN. That sounds interesting. And so do you receive an hourly wage for that?
Yes, I do.
How much are they paying you per hour?
I am getting $24.89.
Okay, $24.89 per hour. And do you have a set schedule? Do you have the same number of hours every week, or does it change?
It changes.
Okay, and so what's an average week? About how many?
Average week is 40 hours, but I get paid bi-weekly, so that's 80 hours a pay period.
Okay. Okay, you answered
Sometimes a little bit of overtime. Other than that, that's it.
Is it ever fewer than 40 hours?
When COVID hit, yes.
Okay, but other than some sort of an emergency like that, you typically would always have at least 40 hours?
Yes.
All right. And so you answered that you get paid every 2 weeks. What is your take-home amount every 2 weeks? Do you know that number?
With taxes or without taxes?
Yeah, what you take home after the taxes have been taken out.
It's usually about $1,400.
Okay, about $1,400 every 2 weeks that you take home, and that's what you pay all your bills with.
Correct.
Okay. So approximately $700 per week on average.
Correct.
Okay. And do you have any other jobs?
No.
Do you have any other source of support other than that one job?
No.
And who lives in your household with you?
My son.
How old is your son?
My son is 27.
Okay.
He lost his job back in November.
All right. So your son is 27 and at the moment he's not working since November?
Correct.
And does anybody else live there besides the two of you?
No, that's it.
Do you claim your son on your taxes as a dependent typically?
No.
Is your son dependent on you at the moment based on his unemployed status?
Yes.
Does he contribute, to have any way to contribute to any of your household expenses?
Not at this time, but prior of him losing his job, he did pay a little bit of rent.
Did he, back when he was working, did he make more money than you or less?
Less.
Okay. All right. So, all right. I guess those are probably all my standard questions, Mr. Pritchard. Let me let you jump in with any other follow-up you want to ask.
Yes, thanks for attending, Ms. Mangan. It helps. I'm going to focus a little bit on some questions about your son. Is he disabled in any way?
No.
You mentioned is he living with you out of the circumstance of the job loss, or has he been living with you since he was, let's say, reached majority, 18?
He's always lived with me.
Does he go to school?
My son is actually on the phone. If you want to.
How's everybody doing?
No, I don't need to speak to him directly.
Okay. Yes, he is signing up for school.
And there's no contribution as far as to the household expenses?
No, not at this time.
Is there any, do you know and whether or not he has applied for unemployment?
No, he has not.
What was his previous job?
He works for a plumbing company.
Does he file his taxes separately?
Yes, he does.
And just to reiterate, there's no infirmities that you're aware of that's preventing him from being on his own?
Well,
there's no disabilities. I'm talking about physical.
No.
Physical or mental.
No.
Okay. Okay. Is the information as far as your address and you've just provided your address on the claim of exemption form. Is that still correct?
Well, what's the address that you have?
4180 72nd Avenue.
Northeast, yes.
Okay, Northeast.
Mm-hmm.
Okay, Naples, Florida. Your Honor, you asked the questions I would have asked. I made some inquiries about the defendant's son. You know, I do not think he qualifies as a dependent. He is not listed on her tax return as a dependent. 27 years old. There's no physical or as testified as any physical or ailments that would lend itself to extra care. Basically, other than obviously being the son, it's a roommate situation, and I really don't believe that he, unless there's some other evidence showing some linkage to the exemption claim, I don't believe that there is a claim of exemption here, and would respectfully request that the claim be denied.
Okay. Ms. Mangan, any argument or any other information that you want to offer in response to Mr. Pritchard's argument?
Yes, I am supporting my son at this time until he gets a job. I am the sole provider. I am the head of household, and I want my wages should be exempt. I can't pay my bills when you're taking money out. I can't pay my mortgage. I can't pay my car payment. I am supporting him at this time until he gets a job.
Okay. I'm hesitating because I feel for you. It doesn't sound like there's any.
I do too. I mean, I'm.
He either could get a job or get unemployment benefits or do something here to help you while you're struggling. That's difficult. But Mr. Pritchard may be correct in terms of legally having a dependent. If you were in a position to claim him on your taxes, if he had some form of disability that would make him dependent, certainly if he's filing his own taxes and getting a refund, I hope he's forking it over to you. But I don't know that there is a legal dependency established by what you have here. You have what I would call a de facto dependent, but he's not legally dependent. It's just he's got to go out and get a job. And so, he can sign up for school if he can afford to on top of working and paying bills. But I can't really hold this creditor at bay on the testimony you've given me. Now, I will say that there are federal guidelines in your wages have to be over a certain amount. If they drop below a certain amount, then there won't be a garnishment based on the federal floor that's set. But it sounds, Ms. Mangan, as though already they've been pulling out and just withholding a certain amount from each check. Is that right?
Yes, 25% of my check.
Okay. Yeah, because I think at the moment you're earning over that floor, which is like 30 times minimum wage or something.
Yes.
Mm-hmm.
So with some disappointment or regret, I have to confess I can't find you exempt. Now, having said that, I will say, as I say to everyone in this position, whether or not I find them exempt, I always tell everyone that you, regardless of the garnishment, you do have a judgment. And this judgment dates back to 2008. Is your son Marvin Carpenter, or is that somebody else?
Just somebody else.
Okay. You have this judgment with Mr. Carpenter. It was $16,000 in 2008. So I don't know if payments or garnishments or other things have been active since then to chip away at this, but with interest, those things grow over time, and it is still out there. The garnishment will allow you to chip away at it. That's the I hate to say silver lining because it doesn't feel like one, but it'll at least chip away at it. But the other thought that I always mention to people, Ms. Mangan, is that you're always free to speak with Mr. Pritchard and see if there is something that may be mutually agreeable. I can't force him to agree to what you might think is reasonable, but I do always mention that. Mr. Pritchard, have you got any thought on that?
Yeah, no, I honestly, I don't, the law provides it, but I don't enjoy doing this part of it. And particularly in this circumstance and particularly this time. I do look, as the judge pointed out, I do look at the age of the judgments. I do look at credits or efforts to pay, and I have no credits on this account. I don't know who, if they're, in the past made arrangements, if it's the co-debtors, if there are things that they can pay and at least cover this or more. We release garnishments and things like that. So, there's a lot of agility, but a lot of it goes to contact and being in, sort of working together. I don't, and if this is a nudge that maybe gets that going, I'd much prefer not to garnish. But I just, with the testimony, Your Honor, I don't know what I can do other than suggest ways of.
Ms. Mangan, boiling that down, it may be helpful to you to speak to Mr. Pritchard directly and see, if, for example, I'm going to use fake numbers. I don't know if these are real, but if, for example, $250 is getting pulled out of each check and you can't afford that, but you could afford $100, it's possible that you talk to Mr. Pritchard and agree to that lesser amount. So even though you're not exempt, you make a plan, and that way you don't get any more surprises, you don't get a disruption, because I know this has been disruptive to you. That's the sort of thing that sometimes people are able to do, but I can't really play a role in that. I just can let you know that that's an avenue open to you. Do you have any questions, Ms. Mangan?
Yes. Did they try to go after Marvin at all? Did he get served any papers?
The garnishment is just something they do, to each of you independently. I don't know.
Yeah, we're always, we look. I mean, we're not solely, obviously someone who's employed, or if there's information. Again, these are part of the things that I think the judge was alluding to. If there's information we can get, I'd prefer you not having to pay the judgment. I'd prefer go elsewhere if I can, if there's the ability. Just going after, adds also a ton of money to the costs of doing that as well. So the opportunity is there. Please reach out to either me, if I'm not there, my staff. And, if we can start a dialogue, I'd be happy to, we can engage in something. But at this point, right now, snapshot right now, I don't know what there is out there. But again, I always leave the door open to that.
Okay.
Ms. Mangan, I think you've got paperwork from Mr. Pritchard's office, so you could reach out to him at your convenience. You can reach out after we hang up today if you want.
Well,
okay,
I have hearings today, but if I can give Ms. Mangan the file number, so if she calls, she can go directly to. We have particular staff members directed to this file, and she can certainly talk to them, and they relay to me. Then I get back. I mean, I'll get in the loop for sure. Your file number is J08-00615. And if you just refer to
00615.
Yeah, J08-00615. If you call the 813-229-0900 number and ask for that file number, they'll switch you to a representative.
Okay. So in the meantime, my check will still be garnished for Friday.
Yes.
Yes.
Is that correct?
Yes.
Okay.
Yeah, so you may want to hop on the phone, when we hang up. It sounds like Mr. Pritchard himself won't be available. Perhaps someone in his office will, and you can see whether there's any chance of reaching an agreement. I know that number that he just gave you is on.
It's on the paperwork.
Yeah. So.
And if you would give me a little bit of time to write notes in the file so people can read them on the system. You give me an hour or so, I'd appreciate that. I have another hearing in front of the judge as well, a little bit. So.
Okay, I have patience as well, so I probably won't be able to do it right now.
Okay. Well, good luck.
I will, Mr. Pritchard, I'll ask you to simply forward an order that indicates that Ms. Mangan's claim of exemption is denied.
Okay.
And then you'll either, best case, you'll send me a document that reflects that you all reached an agreement, perhaps maybe for a smaller amount or something.
Yeah.
Worst case, you'll send me an order that makes that garnishment an ongoing process for so long as Ms. Mangan works at the hospital and continues to owe on this judgment.
Very good.
And I also spoke to an attorney last night in regards to filing bankruptcy. So I will contact my attorney and I will talk to him. I cannot afford to have my wages garnished. I just can't do it.
I would strongly, if you're upside down and things like that, I welcome that. That's what it's for. And please do so.
Okay.
Ms. Mangan, we wish you good luck, and I can appreciate, we'll keep an eye out if a bankruptcy document is filed.
Absolutely.
Then that puts the brakes on this process. So, but until that's done, then we'll just await further word, okay?
All right, thank you.
if you do get a bankruptcy person, please make sure they reach out to us so we know. I don't want to be filing stuff, and you know, I want to make sure we know as quickly as possible.
Okay.
Thank you.
Okay. Thank
All
you.
right. Good luck to both sides. That'll conclude our hearing. We'll be in recess until 3 o'clock.
Thank you very much.
Thank you.
Come on.
Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. I've got one matter set at 3 o'clock, which is asset acceptance versus Rodman. Have I got somebody here for asset acceptance?
Good afternoon, Judge. Julia Hodges for the plaintiff.
Okay. Hodges. Okay, and I think I have Ms. Rodman, whose screen is sideways. I don't know if you're able to turn that screen. There she is. Okay. All right, Ms. Rodman, and then I have Attorney Piles. Are you on this case, sir?
Yes, I am representing defendant Rodman.
Okay. All right. Have both counsel spoken with each other yet?
Oh, no, Judge. He and I have not. I don't know about the file from you.
Okay. Mr. Piles, I didn't know if you'd been able to work anything out or if you all just want to proceed with the hearing.
Yeah, unfortunately, I wasn't able to reach out to them prior to the hearing, but it is pretty straightforward. So I think it should be pretty quick to resolve.
Okay. All right. Well, Ms. Rodman, let me have you raise your right hand to be sworn. Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? Okay, we don't have, I gotta have you unmute there.
She has to unmute her screen.
Yes?
Yes.
Okay. All right. What I'm going to do, it tends to move a little more quickly. I'm going to just ask some standard questions of Ms. Rodman, and then I'll invite either of you to fill in other questions that you want to explore. Ms. Rodman, are you employed?
Yes.
Where are you employed?
I work at Preferred Care Home Health.
What do you do for them?
I'm a licensed practical nurse.
Okay. My last hearing was an LPN as well. And do you get paid by the hour?
I get paid per visit.
Okay. All right. Well, how much do you get paid per visit?
I get $40 a visit because I'm seeing COVID patients.
And do you have a consistent number of visits each week, or does it fluctuate?
It fluctuates.
What's a busy week look like? How many visits?
A busy week would be about 35 patients.
And what's a light week look like?
Usually 20.
Okay. All right. So it sounds like it's almost like having $40 an hour, and you're anywhere from 20 to 35 hours a week. I'm sure it's more time than that because you're having to run around. And so how often do you get paid?
Every 2 weeks.
And what is the actual amount on the check that you take home if you had a busy week? How much are you taking home from a busy week?
I take home on a busy week $2,000 to $2,100.
Okay. And is that actually for the busy 2 weeks?
Yes.
Okay, so about 1,000, 1,050 for each of those weeks.
Mm-hmm.
And then what if things are slow? What's a smaller check look like for every 2 weeks?
I would probably bring home 15 or 16.
Okay. So about 1,500 on the low end and about 2,100 on the high end. Is that right?
Right.
Okay. And do you have any other employment?
No.
Any other sources of income?
No.
Who lives in your house with you?
Just my daughter.
How old is she?
11.
And does anybody else help you support her?
No.
Her father doesn't contribute in any way?
No, he's in Ireland.
Okay. Is he helping to cover her medical expenses or anything at all?
No, I have her on health.
You have what?
She's on Healthy Kids.
Okay. All right. And so your testimony is you're 100% responsible for an 11-year-old daughter?
Yes.
Okay. Do you support anybody else other than yourself and your daughter?
Nope, just just us.
Okay. And other than things like healthy kids, there's no one else that's contributing to your daughter's support and well-being?
No.
All right. Mr. Piles, I stepped on your toes, sorry, but anything else that you would like to elicit from your client before I invite Ms. Hodges?
No, just the one final thing is that she is single. She's not married.
Okay. All right, Ms. Robin, that's correct?
Correct.
And Ms. Hodges, any other questions that you'd like to ask of Ms. Rodman?
I just have one question. Ms. Rodman, does your daughter's father have any kind of time sharing or visitation with her?
No, he's in Ireland. That's where he lives.
We're talking 0 days or 0 overnight.
Yeah.
Okay.
Yeah.
No, I have no other questions.
Okay. All right, Ms. Hodges, any argument with regard to the claim of exemption?
Not really, Judge. It sounds like she's qualified.
Okay. Mr. Piles, I can step on your toes again. It's rare that I have an attorney in your position. It's a nice luxury, but I do keep an order handy. My assistant kindly prepared one with Ms. Rodman's information, and I can, with a few clicks, go ahead and get that order out that will state that Ms. Rodman did meet her burden in establishing her exemption to garnishment, and will order that this particular writ of garnishment is dissolved, and that would go out to everyone. Mr. Piles, any objection with the court doing that?
No objection, Your Honor.
Ms. Hodges, any problem with that or any concern?
No objection, Judge.
The only other thing, and this will be the last time I step on your toes, Mr. Piles, but I do always mention to folks in this position that the garnishment is sort of the battle and the judgment is the war. The garnishment will go away, the judgment remains. And so I always encourage folks, and perhaps Mr. Piles can speak to Ms. Hodges after we finish, if you have any ability to negotiate anything or agree to something, if they're willing to agree, I can't force either side to agree, but if you're able to find middle ground, then you may be able to set something up that means that you'll have some certainty. You won't have any more disruptive surprises like this. But if you're unable to do that, then just know that it is possible and quite common for folks like Asset Acceptance to periodically reach in and try to collect even some of the outstanding debt. So if you're able to, it can be beneficial as long as you set an amount that's affordable for you. And I know affordable is a tricky word right now. Mr. Piles, anything else that you would have us address or that you would add to what I've just stated?
No, not at this time.
Ms. Hodges, anything else from plaintiff?
Nothing from the plaintiff, Judge.
All right. Well, I know you all can get in touch with each other if there's any other discussion to be had. If not, I'll take care of the order on the garnishment now and wish both sides good luck going forward trying to get this all sorted out. Thanks, everybody.
Thank you, Judge.
Thank you.
That'll conclude our hearing. We'll be in recess till 3:30. Okay, good afternoon. This is Judge Martin. Welcome to Collier County Court. Looks like the attorney is logging in here. Mr. Pritchard, do I have you? Okay. All right. Now Mr. Pritchard is on, and ma'am, I'm going to ask you to unmute. Okay. Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
How do you pronounce your last name, ma'am?
Metellus.
Metellus. Okay, Ms. Metellus. It looks like the video is kind of going in and out. Are you able to raise your right hand so I can see it? Video's frozen right now. I don't know if you've got if you're headed to a spot that's got a better signal. Oh, no. Oh, there she is. Perfect. Okay, Ms. Metellus, and one more thing, I'm going to ask you to unmute yourself again. Now we're good. Okay, do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, great. I'm going to ask you some questions about your claim of exemption to garnishment.
Yes, ma'am.
Let's see what we can find out, okay?
Okay.
Would you tell me your full name?
Rosemond Hyacinth Metellus.
Okay, and Ms. Metellus, are you employed?
Yes, ma'am.
Where do you work?
Hover around.
Okay. All right, what does that company do?
We sell and manufacture power wheelchairs and scooters as well.
And what do you do for them?
I'm an intake specialist.
And do they pay you by the hour or a salary?
By the hour.
How much do you make per hour?
I'm not sure exactly. I think it's like 14 something, 25 or something.
Okay. And I'll put 1425. They filed an answer, but it's kind of, Mr. Pritchard, I've always thought it was dumb that question's not on the.
I know. I do too, because
do you have a pay stub, ma'am?
Yeah, I could probably, if you don't mind, I can go on really quick and see.
Okay. Well, let me ask a few more questions, and then I might have you do that.
Okay.
So you think it's about $14.25 an hour, and do you have the same number of hours each week? Is it consistent?
Yes, consistent. I work 40 hours.
Okay. And how often do you get paid?
Bi-weekly.
And after they take out taxes and everything, can you estimate what's the check you take home every 2 weeks?
About 900.
Okay. And so about $450 per week is the average?
Yes.
Okay. And do you have any other employment?
No, ma'am.
Anybody else helping to support you or pay your bills?
No, ma'am.
Me neither. I get it. So tell me about your household. Who lives with you in your home?
Me and my 4 kids.
4 kids. What are their ages?
18, 15, 10, and 4.
Okay, 18, 15, 10, and 4. Anybody else live there besides you and your 4 kids?
No, ma'am.
Any of those kids working and helping you pay bills?
No, my 18-year-old is still in high school.
Okay. And what about any child support on any of those kids?
No, I actually have a child support case open, but it actually, since with COVID, it's been, nothing's happened. I was waiting for a paternity test for my 10-year-old. My 2 oldest son, their dad was deported, so
okay.
I can't get child support, so I don't get child support at all.
All right, and obviously he's not sending any voluntarily?
No, and because he's in Haiti, I guess they don't work, child support services don't work with them.
Okay, so the two oldest, their dad was deported. You're working on paternity for the 10-year-old to see if you can pursue support. And did you say you already have a support case open on the 4-year-old?
Yes, we're just
nothing's
nothing-
coming yet?
no, ma'am.
Okay. Okay. And so does anybody help you support those kids? Maybe your family, anybody else helping you to pay their needs?
I get food stamps.
Okay. All right. So some public benefit.
And then I get childcare.
Okay.
Benefits. That's it.
Okay. Okay, Mr. Pritchard, any questions that you have for Ms. Medalist?
Yeah, how do you do it? I mean,
Yeah.
I mean that's
I know.
that's my question, really. I mean, that's. I mean, my questions were more related to the support from other sources with 4 children, obviously, and it seems like you're trying, but you know, there's only so much you can do. Yeah, I'm not going to waste the court's time with any.
Okay. Yeah, it looks like the employer's answer had the income.
Yeah.
Closer to 1,000, but still, that's not going to make any big difference with 4 kiddos. So.
Yeah, Frank. Yeah, and we have three minors.
Yeah.
1 in high school, hopefully maybe going to college. You know,
Yeah. Well, Ms. Medalist, I have an order, and Mr. Pritchard, this is, it wasn't relevant in our last hearing, but I have an order on my system ready to go.
That'd be.
It has all of Ms. Medalist's information in it that will indicate that she has proven what she needed to prove today, and it will grant her exemption and dissolve the garnishment. Is that
Very
okay?
good. No, that's fine. Quicker
Okay.
they get to her employer, the better.
Okay, I'll get that filed right away. And let me just check one thing, Ms. Medalist. It looks like medalist.rosemond@gmail is your email address?
Yes,
Okay.
ma'am.
So you'll get a copy of that order when it comes out here in just a few moments, okay?
Thank you.
And Ms. Medalist, you know, at some point, if circumstances change, when the kiddos are grown, or if you're able to get their dads to start chipping in, you can always reach out to Mr. Pritchard and try to see if you can set up any kind of plan to chip away at this. Otherwise, it's possible, Mr. Pritchard probably won't do it, but it's possible somebody comes along in a couple years after him may again do this, and I know it's disruptive. So if you become able to set up a payment plan, reach out, try to do that. But for today, you're all set.
Yeah, a lot of it is just keeping in touch, Rosemond. It's like, you know, it is what it is. The facts are the facts, and you know, you seem like you're doing, you know, yeoman's work. So, you know, good luck to you, and
Thank you.
I hope you're able to get some at least assistance from somebody, and the dads would be preferable.
Yeah. All right. Well, Ms. Medalist, I'm going to get that order out right now before my next hearing starts. So you'll see that email, and it will also go to your employer. But you're welcome to you know, take that as well. Hopefully they'll lift the hold, and any money that they have been setting aside, they'll give all of that back to you.
Thank you.
Okay.
Thank you.
All right. Good luck. Good luck.
Thank you. I appreciate it. Have a good
Thank you.
one.
Thank you very much, Your Honor.
Good luck. That'll conclude our hearing.
Okay.
Thanks, everybody.
Bye
Stay
now.
well.
Bye.
Good afternoon, Your Honor. Christopher Mast. Gilbert, can you hear me?
Yes, I can hear you.
Oh, good. Judge doesn't seem to be on yet. So how are you doing today?
I'm doing all right.
Good.
It's another sunny day in St. Croix.
What's that?
Just another sunny day in St. Croix.
Yeah, it's a kind of hot day here too, so another day in paradise. At least it's 3 o'clock there versus 4 o'clock here.
Actually, it's 5 o'clock here.
Oh, okay.
We're an hour.
Your house looks very pleasant.
It's in a state of turmoil.
Well, this house at least.
This one's been the kitchen's been under construction since 2016.
Oh, good God. That's a bit ridiculous.
It was moving along very nicely until the hurricane hit in 2017. And everything,
your problem.
Everything came to a stop, and the guy who was doing it went weird and quit the job, and never seen him since.
I'll find somebody else.
I've been wanting to, but financially, I'm just kind of like, okay, let me.
Yeah.
The money, but every time I think I am, something else happens, and like court proceedings.
I understand. Hopefully, Miss Leaf will be dialing in too.
Well, if not, then she pretty much loses, doesn't she?
No, I meant the person. It's
Eileen.
Rent to.
Eileen.
Yeah, Eileen Leaf.
Yep.
Yeah, I talked to her a couple of times, and supposedly she's going to call in. She emailed me back on everything, so I expect any minute she'll be tiling into it, and then I got my witnesses, and then maybe Leanne will show up. But if not, thanks for that problem.
Yep. Yeah, and at this point, just get her out as quick as you can, since she's not responded to.
Well, there's not much else I can do other than what we're doing today. I can't do an eviction. So.
No, I realize that, but all I'm saying is there's no reason to give her any more chances.
No, I agree. But they're going to be careful. I think we're the only ones on this so far that I can see. So. Yeah, I'm working timing. I'm flying out of Florida tomorrow. It's 8 o'clock in the morning. So I already got proposed judgments prepared and all the rest of the stuff. I got Lexi lined up to do the writ of possession if we can get it. So otherwise, so you keep busy?
Yeah, busy enough, no problem. Every day kind of fills up.
Yeah, it's kind of the way I feel too. Although today I was kind of wishing it was less busy so I could get going and get things packed up and get ready to leave tomorrow morning.
Sure.
It's always the way it happens though, I think.
So are they doing anything special on the flights in terms of the COVID thing, or?
No, they just I do fly Southwest, and all they do is you got to keep your mask on at all times, and they give you a little thing of peanuts or a trail mix or whatever you want to call it, and a little tiny glass of water. And I usually don't drink the water because if I do that, then I got to pee, and I hate to try to use an airplane bathroom. So I'm not sure I'd fit in one anyways. Miss Leaf, you're muted. Hi, Christopher Mast, ma'am. How are you today?
Good. How are you?
Good. Thank you very much for joining us on this. I appreciate it.
Yeah, my pleasure. If I can help.
And just so you're aware, I'm just basically going to ask you how you met Leanne Moore and that kind of, basically about the situation involving the rental and what she indicated to you as far as her ownership interest of the property.
Yeah, I sent you the text that she had sent me. Did you get that?
Yes, I did. Very bizarre text.
Mhm.
Let me go to that real quick. Yeah, she has a 50% ownership interest.
Mhm.
The heck happened to my, oh, here we go. Yeah, very strange. And I don't even know if she'll show up, so hopefully the judge will be here any minute now, and then we can go from this and everybody goes their separate ways again. And I have
He's
Dr.
supposed to
Ross
be
on here,
here?
Dr. Ross on here as well.
Hello.
Nice to meet you for the first time.
Good to meet you. You have a lovely home.
Thank you. I'm even alive.
That's great. Yeah, that's a good thing too.
I guess the rumors about me being dead were premature, as Mark Twain would say.
Exactly. Yeah, that's very good. Good to hear.
So you're going to be going to Naples for the winter at all, or?
Not this year because of the COVID restrictions, but I said, if you ever want to really rent your house, I'm happy to rent it next winter.
The only problem is it's against my homeowners association regulations.
Yeah, just don't tell them.
Oh, yeah. That's a beautiful community.
It is.
Oh, and there's Miss Moore. Missing scarf. Look at that.
Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. We've got one matter on the 4 o'clock docket, which is styled Ross versus Moore. This is an action for unlawful detention. And I believe plaintiff has counsel. Do you want to state your appearance?
Good afternoon, Your Honor. Christopher Mast representing Gilbert Ross.
Okay, Mr. Mast, good afternoon. And based on everyone's titles, it looks like I have Mr. Ross present, and I do have, it says Leanne's iPad, so I'm going to assume that's Ms. Moore.
And then I also have one witness along with Dr. Gilbert of Eileen Leaf.
Okay.
Hello?
All right. Is that you, Ms. Moore?
Yes, Judge, it is me. I'm sorry, I'm a little technically challenged, but doing my best here.
That's okay. So, and you can hear me and I can hear you. So that's good. All right.
Yes, Judge.
Okay. So I've got, and it's, is it Dr. Ross then?
Yes.
All right. Dr. Ross, Ms. Leff, and Ms. Moore, along with Attorney Mast. This is an action for detainer. And Mr. Mast, I'll invite you to go ahead and proceed. Let me just, I'll get all three witnesses sworn. Ms. Moore, Ms. Leff, and Dr. Ross, if you'll all three raise your right hand. Ms. Moore, can you raise your right hand so that I can see it? There you are. Do you all solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, everybody can put their hands down. Everybody's been sworn. And you can put your hand down, Ms. Moore. All right. And Mr. Mast is going to call his first witness. Are you hearing okay, Ms. Moore?
Yes, ma'am, I am.
Okay. Go ahead, Mr. Mast.
Okay, very well, Your Honor. I would call Dr. Ross. And as you pointed out, Your Honor, this is simply an action for unlawful detention. So obviously we're here determining right of possession only. Dr. Ross, you there?
Yes, I'm here.
Okay. Are you the owner of the property located at 7205 Mill Run Circle, Naples, Florida?
Yes, I am.
And what is your full name for the record?
Gilbert Jeffrey Ross.
Okay. And when did you first purchase that property?
It was actually purchased under my deceased wife's name in, I think, 2004.
Did you own the property jointly with her?
Pardon?
Did you own the property jointly with her?
After, I guess a year after that we did, and then when she died, it became my sole property.
Okay. And do you live there?
Part-time.
Okay. Who else currently lives there?
Right now, Leanne Moore is living there.
And how did Leanne Moore come to move into that property?
We met in 2019 or 2018, the very end of 2018. And at the very beginning of 2019, meaning right at New Year's time, she was in the midst of moving out of one place and renting a room from a very old man, a sickly old man in Laley. And as it was occurring to me, she didn't have a good paying job. She was paying, like I said, moving into a single room. And I said, I have a, virtually a vacant house. And if you would like, I could allow you to stay there for a while.
Did you two have a romantic relationship?
We had one for a while, yes.
And did you execute a lease agreement with her when she moved in?
No, I did not.
Has she ever paid you any rent?
No, she does not.
Does she pay any utilities?
Pardon?
Does she pay any utilities?
No, she doesn't. She does not pay anything.
Does she maintain the yard or the landscaping?
No.
Does she maintain the pool?
No.
Does Leanne Moore make any contribution to the upkeep of the property?
No.
At any time during this relationship, have you provided her with money for food?
Yes.
And have you given her any gifts?
Yes.
Such as?
A pair of diamond earrings and several bracelets and earrings from down here in St. Croix, where I'm at right now, from a local shop, and a string of a pearl necklace, and there was one afternoon we bought a lot of clothes for her.
Did she ever buy anything for you?
No.
Do you maintain security cameras at the property?
I did when she first moved in. I had 6 security cameras in place. And then after about 3 months, they all disappeared. Were not seen again.
Okay. Did you remove the cameras yourself?
No. In fact, I asked for them to be replaced be put back in position, and they were not. And I do not know where the whereabouts of those 6 cameras are right now.
Who did you ask to place the cameras back in position?
Leanne Moore.
Prior to Leanne moving into the property, were you in sole possession of the property?
Yes. And I had no caretakers previous to her moving in.
Is this property, can you describe the property?
It's a ranch style, one floor house, about 3,000 square feet. And I think it was built in 1995, and we renovated in 2004 to 2005.
When you say we, who are you referring to?
My deceased wife and I.
Is this a single family house?
Yes, it is.
Does the property require a caretaker?
No.
Did you ever tell Leanne that you were hiring her as a caretaker and you would pay her salary by allowing her to live there for rent?
No.
And after you withdrew your consent for Leanne to stay there on January 5th, has she vacated the property?
No.
I have no further questions of this witness, Your Honor.
Okay, you want to call your next witness?
Eileen Leaf. Am I pronouncing your name right, ma'am?
It's Leff. Yeah, it's Eileen Leff.
Leff, okay, I'm sorry. Again, could you please state your name for the record, ma'am?
Eileen Leff is my name.
And have you ever met Leanne Moore?
Yes, I have.
And what were the circumstances of meeting Leanne Moore?
I met Leanne January 7th, 2020, because I had an agreement with her to rent that house. I used to own a house in Naples, and I wanted to come down there with a friend, and we wound up finding this house to rent.
When you say this house, are you referring to the house at 7205 Mill Run Circle?
Yes.
Okay. And what was the agreement that you had?
My friend and I, she had said, Leanne Moore had contacted a friend of ours through a website, and she said that her husband had died and she had 2 extra bedrooms and she would like to rent them. And so we were looking for a place to rent, and it sounded good because we had lived in the area. And so I sent her a check for my share of the first month's rent, which was $1,500. And I said that I would come down January 7th and, be there to rent the place.
So the rent was $1,500 each?
Yes, so it would have been $3,000 a month, and we had an agreement to go month by month, but it was supposed to be for at least January and February and possibly March.
And how did Ms. Moore represent herself with respect to the property at issue?
Well, I asked if she had said that she was the owner and her husband had died, and I asked her if she owned it, and she said then that she was in a 50% partnership, an investor, and that it was the same investor that she had another 50% partnership with in a home in St. Croix that was under construction, and that's where he resides, and that she would probably, while we were there, go in the next couple of months to see how the construction is going in St. Croix.
Did she indicate why she was renting out the bedrooms?
It just, I know, I just, no.
How long did you stay there?
I just heard that she might be lonely.
How long did you stay there?
What's that?
How long did you stay
I
at the
just
property?
stayed one night. I just stayed one night because when I got there, she had not given me the gate code. And then she did come out, and when I got to the house, the beds were not made, so the rooms were not ready. And it just seemed odd to me. And I had told her not to get any food. And so she showed me that there was a freezer full of $300 worth of food that she had gotten. And there was no internet. And that night I called my friend and said it sounded very strange, and that the other room was not ready at all, and there were, I guess, things in it that it would have to be moved and so on. And it just seemed odd to me. And then in the early morning, her dog started yapping. So I figured, I'm addicted to the internet, and I work and I need the internet, so it was no internet available. So I said, and then Leanne said to me, well, maybe you don't want to stay here. And I said, you know, I think you're right. So I left, and she said she would give me my money back at the end of January, because she didn't have it right then, because after all, she bought all that food. And so I agreed that we would meet an agreed place at the end of January for me to get my money back.
Did you get your
And
money
I
back?
still haven't gotten it. No, and I still haven't gotten it back.
Did you ever find out who actually owned the property?
Well, I know about Collier Appraiser, and so I researched it, and I found out that Dr. Ross owned it. And as a researcher, I found out how to reach him, so I called him and told him my story.
I have no further questions, ma'am.
Okay. You want to call your next witness?
I have no further witnesses, Your Honor.
Okay. All right. Ms. Moore, is there anything that you would like to advise the court about the situation?
Yes, and going through, so I made a couple of notes on some things. First of all, I was invited to live here for as long as I wanted. It was a verbal agreement that I would watch over the house, and I've dealt with roofers, plumbers, his insurance company, heating and cooling people, and he was providing food initially, and then he just stopped, and I was not making too much money. You know, he knew what I was making hourly. He cut the cable, and he just started to, you know, cut things out, you know, to just make it difficult for me. I happen to suffer severe bipolar disorder, and I'm in the good care of the David Lawrence Center. And Scott Burgess is a friend of mine through my church, Naples Church. And I'm a survivor of domestic violence, and I have severe PTSD. So this is really rattling me. I unfortunately lost my job because of COVID, and Gilbert knew all of this. I've always kept him up to breast on my, you know, what's happening. Things got so bad for me economically that I was initially interested to try to help out Ms. Les. I thought it would be mutually, you know, beneficial. The two ladies seemed like they would be out, you know, most of the time, and I was desperate, you know, for money and just to live on and to buy food and to put gas in my car. So I'm sorry about that. Eileen and I had an agreement. I was accepted back to work, and then two of my coworkers became ill with COVID. And so I have a bronchial sensitivity, and I chose not to go back because I cannot, it would completely bankrupt me to go into the hospital if I ever got COVID. I've been dealing with NAMI, They've been wonderful, and I'm currently, as I mentioned, working with the crisis team, the care center of David Lawrence, and they're trying to help me sort through, what I'm going through. And I have started to pack, and I have a storage unit obtained, and I have a friend coming in 1 week to help me. I have a fractured right wrist, but my friend is going to help me move my things into storage. I do not have a place to live because of it being high season. Number one, COVID. So many people are reluctant to have people in their homes. And I don't currently have a job, but I am interviewing for jobs, and I can work, and I do want to work. So I've just been, I'm sorry, I sound probably shaky. I just, regarding the security cameras, Judge, if I may just say, it was the Collier County Sheriff's Office, and they knew, because I had shared, I'm a survivor of severe domestic violence, and even his name was Corporal Sparacino. He told me that, I could take down the security cameras. They were inside and they were focused on me at 24/7, and I don't like to be photographed. So there was no meaning in that, just for my own privacy sake.
Okay.
So
those cameras are probably available then for Dr. Ross to restore.
Yes, ma'am. Yes, Judge.
Okay. Well, let me focus us in a little bit. A lot of the testimony from Dr. Ross and Ms. Leff ultimately isn't really critical here today. What we have is a scenario where Dr. Ross has allowed you to stay in the home, and he's certainly free to do that. Under Florida law, he's also free to revoke his consent whenever he may wish to do so. And what I'm looking for here is whether there is any legal claim that you might be able to assert that would give you the right to continue to stay in the home after he has now withdrawn his consent for that. So I'm looking for either an ownership interest or a landlord-tenant relationship that would potentially give rise to a right to stay after he asks you to leave. I'm not hearing it or seeing it in what you have said, and it sounds like you are making your way out of the home. So I'll give you one final opportunity. Is there anything else that you would assert that should give you a legal right to stay over Dr. Ross's objection? I'm not hearing anything. Are you speaking, Ms. Ross? The phone's not muted. I can't see your face. I was hearing you just fine a moment ago. I'm not hearing you now. The telephone that was working, serving as the microphone, although it says it's an iPad.
Can I just correct one thing?
Hang on just a second, because I need to get her reconnected here. And for what it's worth, Dr. Ross, 90% of what's been said by both sides is not necessary.
Okay.
You own the house. You let her stay.
Mm-hmm.
You've asked her to leave. Those are really the three bases that have to be tagged. Everything else is superfluous. Well, Ms. Moore, if you don't reconnect, I'm not sure that there's really anything else I need from you. I'll give you just a few minutes to try to reconnect, and then I'm just going to go ahead and conclude the hearing, because again, I've heard all the evidence that I need. Okay, I see you're trying to call in. As soon as it pops up on my screen, I'll admit. Here we go. Okay, you there, Ms. Moore?
Hello?
Yeah, there you are.
Yes, I'm so sorry. I'm a little technologically challenged, and my
Okay.
phone just went off. So I apologize, Judge.
Anything else that you wanted to assert that might give you a legal claim to continue to stay in the house now that Dr. Ross has asked you to leave?
Well, I asked Dr. Ross, trying to communicate with him 2 days ago. I have something to move into March 31, and I'd be happy. I don't know if I could afford more than, say, $600, to stay until then. I can't get into a place until March 31. I've been working frantically and diligently in just trying to secure something. So I would be happy to pay, $600, and just try to work with Dr. Ross on just a peaceful, cooperative leaving here. And I also thought that with my, with my bipolar, I was researching things under the Fair Housing Act, and to see if that is a viable way of protecting, my rights. I mean, not to just throw me out on the street.
Right. Okay. Well, and frankly, I'm sympathetic to both sides. It's a difficult and awkward situation all around. Mr. Mast, I don't know if we need to detain Ms. Leff, although Ms. Leff, you're welcome to stay on. Mr. Mast, do you anticipate?
No, I have no further questions, Your Honor.
Ms. Leff, you're welcome to stick around, but if you need to get going, you're welcome to. And I'm going to wrap up with Mr. Mast and the two parties. But thank you for your testimony, ma'am. What I'm going to do is this. Ms. Moore, I'm understanding the difficulty, but as I've mentioned a couple times, I'm limited. I'm completely limited in what I could do to require Dr. Ross to continue to house you. If he chooses to negotiate an exit date or negotiate a small rent payment or something, he's welcome to do that. But Mr. Mast, I will find that plaintiff has met his burden here to establish the case for detainer. And if you request it, I would grant a final judgment in favor of Dr. Ross to grant him possession of the home. Ms. Moore, you're free to speak, and I think, Mr. Mast, correct me if I'm wrong, but probably as Dr. Ross is represented, I assume you'd like Ms. Moore to contact you if she wishes to offer any negotiation, or would you rather she speak with Dr. Ross?
I have no problem if she speaks to Dr. Ross.
Okay.
But yeah, obviously I would be asking that the court issue a final judgment on the possession.
And that's fine. I'm granting that. I'm determining as of this moment that plaintiff is entitled to that final judgment. With that, plaintiff can get a writ of possession from the clerk and ask the sheriff to serve it. Dr. Ross, you are, as I referenced, it sounds like you don't need Mr. Mast to keep running up bills, but you yourself can speak directly with Ms. Moore if you want. And if you don't, I can't force either of you to do that.
I would advise the court, if I may, that if Dr. Ross indicates that he has no problem with her staying a little bit longer, I would hold off getting a writ of possession during that time period. as long as I had the judgment in my hand.
Yep, and that's fine. So you can get the judgment whenever you submit it to me. And as you've referenced, you can take the second step of getting a writ of possession, which is the paper that would actually empower the sheriff to remove Ms. Moore. You can get that at your option. Some folks never end up needing it. Other folks get it the same day because they're anxious to remove the party. But you all can control the pace of that. I'm simply finding today you're entitled to that. Ms. Moore, the last question, it looks like I've got an email, LEEANNROMA50 Is that correct?
Yes, Judge, that is correct.
Right. So if and when Mr. Mast sends me that judgment, I will promptly execute it. You'll get a copy of that by that email address. And then, like I said, it'll be between you and Dr. Ross as to whether he wishes to give you any time to move out. If he wants to move this as fast as possible, he could execute all of that in 1 or 2 days, but he can move more slowly if he wishes to. That's up to Dr. Ross. It's not up to me. I don't have any authority to force him to house you any further after this point. Do you understand all of that before?
I believe that I do. I'm merely asking just for a little bit more time so I can just peacefully leave and not be here anymore. And I have things lined up, and I have made, I have storage, and I'm putting stuff into storage. I need a friend to help me next week, and I'm just hoping for just a little more time, reasonable time to just to be done.
Okay, that's up to Dr. Ross entirely. I have no authority to make that happen, but I will go ahead. Mr. Masters, is there anything else that plaintiff needs to address?
No, Your Honor, I will submit a judgment to your JA.
Okay.
We'll go from there.
You can send that in Word format, and we'll send it back out, and we'll get copies to you by email and Ms. Moore by email. That's really everything. Yes, ma'am.
I'm sorry. So does that mean I have like 48 hours to get out of here completely?
It does if Dr. Ross moves this as quickly as possible. If Dr. Ross decides to grant you a bit more grace, that's up to him. I don't have any control over that.
Just, Your Honor, if I may, just for Leanne's information, even if I send the judgment up to the court today and you get it back to me tomorrow, the sheriff's department would still need 24 hours to serve it. So the best they would probably do would be Friday, and then they would not do anything until the following Monday. So she's really looking
the sheriff's
at
office?
Thursday, Friday, Saturday, Sunday, Monday at the best case scenario.
So Monday I would have to be out of here.
That's the best case scenario unless Dr. Gilbert tells me something else.
Okay.
Okay. I think that's everything that we need to discuss in court. Did you have a question, Ms. Moore?
No, thank you for your time and trying to explain to me, what's going on.
Okay. I think
Thank you, Your Honor.
We're all set. You all can communicate directly with each other, but this is the end of what I can do to address the situation. So I wish both sides good luck with a difficult situation. Everybody stay well. That'll conclude our afternoon session.
Thank you, Your Honor.
Okay. Thank you.